We are awaiting Mark Mix on the program. While we're waiting for him from National Right to Work, to talk about what happens if Wisconsin Supreme Court goes in the opposite direction, what it means for workers, what it means for small businesses, what it means for the cost of state contracts, what it means for our tax liability. Just three different changes that could easily be made to Wisconsin law. Is Mark standing by, Dave?
I'm here.
Outstanding. There he is. So I was just I was buying time for you, Mark, is what I was doing. If our Supreme Court shifts from a conservative majority, a rational majority, and I shouldn't even call it a conservative majority, a constitutional majority, to a left-wing majority, becomes fully activist in the majority, then there are three key pieces of legislation that are likely to go away, that have governed Wisconsin for a long time, that have helped workers, helped small businesses, and protected taxpayers. And those are Act 10, the explicit private right to work law, and the law on PLAs, project labor agreements. So we can take all three of them, but in the aggregate, they are going to hurt workers, hurt small businesses, make it impossible for any mid-size business to compete for state contracts, and explode the cost of what the cost of state labor and municipal labor in the state of Wisconsin. Good to have you, by the way.
Well, thanks, Vicki. And yeah, this is very serious. In fact, the eyes of the entire nation are on this. Some people, I think the New York Times called this the most important election of 2023, and that is the one seat remaining on the Supreme Court that will decide, to your point, whether this is a legislative Supreme Court or a constitutional Supreme Court. I mean, and this is something that's been going on around the country. The left understands the importance of getting a hold of the judicial branch of many states. And to your point, I mean, the Supreme Court of Wisconsin ruled on Act 10 back in 2014, saying that it was not a restriction on bargaining. The right to work provisions were perfectly fine. Its prohibition on dues deduction was not violation of the union's associational rights or any kind of equal protection. They go back and do that again with a different majority, and all of that rationale for upholding a law that saved, and Vic, I think you've said it more, and I think I remember it correctly, something like the order of $3 billion just to start.
15. $15 billion has been saved because of Act 10. 15, Mark.
Yeah. Secondly, the Supreme Court in the case, the Machinists Union District 10 versus the state of Wisconsin and the Right to Work law. The National Right to Work Foundation was involved in these cases, filing briefs in both these cases and in the Seventh Circuit, federal cases against the Right to Work law, actually arguing in the Seventh Circuit to protect Wisconsin's Right to Work law. But the Supreme Court in Wisconsin ruled that the Right to Work law was not unconstitutional, as the unions tried to argue there. But all of this, to your point, Vicki, is up in the air, depending on the outcome of this election on April 4th, right?
Well, absolutely true, because they've already said the candidate who's running against the constitutional conservative Dan Kelly, a woman named Janet Protasewicz, said Act 10 is unconstitutional, said our district maps are unconstitutional, et cetera. There's another labor agreement another labor law that nobody ever pays attention to, but it allowed non-union companies to compete for state contracts without essentially having to unionize for the process of the state contract, in which case most of the private companies wouldn't do it. And that's project labor agreements. That's this rigged game that was in place in Wisconsin and a lot of states that said you have to pay, union wages, you have to pay into union pensions, you have to provide, essentially a collective bargaining agreement for your employees. And finally, there was movement in the legislature, enough support that we got rid of that as well. So you're talking about giving Wisconsin to AFSCME, to WEAC, to the Madison Teachers Association, to SEIU, to the Teamsters, to UAW, to become their playground again.
Yeah, absolutely, and it really is a question of those things, Vicki. There's no question about that. I mean, we're dealing with it right now in Michigan. The redistricting process there made the Michigan legislative races, balanced in a way that it was very close. But now the Democrats have control. Yesterday, in the House of Representatives there, they voted to repeal the right to work law. And the idea of the benefit for Michiganders is, what's the benefit for Michiganders by allowing unions to force workers to pay union dues? There's no answer to that question. It's simply a political payoff to union officials. In Wisconsin, the same thing's true. I mean, in what way has the right to work law stopped anyone from joining a union in Wisconsin? In what way has imposing prevailing wage laws or a project labor agreement, reduced the cost to the taxpayers on government construction? It hasn't. It only protects monopolies like big labor. And when you can allow other people to compete for jobs, if they can do the job and do it well, and they can do it for a lower cost, doesn't the taxpayer benefit from that? But union officials don't benefit from that. And that's the issue that's in play here in this election. And it's really about whether or not you're going to have a legislating Supreme Court, in my view.
Entirely true. And on the issue of state contracts, road contracts, things like that, basically you had a couple of companies carve up the entire state of Wisconsin. There wasn't competitive bidding going on for those projects. You had large companies carving up Wisconsin. And if you were a smaller company and you wanted to take a go at a project, the requirements that you were going to have to oblige were so expensive, you just didn't do it. You didn't bother. And how does that help the state of Wisconsin, essentially creating what amounts to, a construction cartel operation for state projects? Doesn't make any sense at all. As far as Act 10, all Act 10 did was say, if you want to take out union dues, if you want to be a union member and your dues are going to come out, the union's going to have to expect you to pay them. Instead of the state becoming the bank, the banker for the unions, it's going to be on you and your union to come up with a way for you to pay your obligated dues. It also said you're going to have to pay 12.7% of your premiums, not of the total value, your premiums for your health insurance, 12.7%. I mean, it's barely a breeze to your bank account. And you're going to have to contribute to your own pension. You'll not the value of the pension, but the set aside for you to invest. That's all it said, Mark. And this woman is saying it's unconstitutional, even though it's been challenged multiple times.
Yeah, indeed. I think most of your listeners who are not government employees would like that same deal, wouldn't they? 12.7% of their health insurance premiums and
50%
and I think,
of the contribution to their retirement.
Yeah, that'd be a pretty good deal. But, getting back to the project labor agreements, I mean, we know from experience around the country, these project labor agreements are presented as being ways to make sure that things end, construction projects end on time and they come in under budget. That is absolutely the opposite of what actually happens when you have limited competition and you have union officials who know that they have the power to hold these things down. They often go way over budget and they don't come in on time. I mean, union officials testify about that in these hearings. Oh, yeah, we guarantee it. But the reason why we guarantee it is because we won't use the power that we have to strike or slow things down or use the power of our monopoly to basically say, you do it our way or you're going to be in real trouble. And that's exactly what this is. Like, we'll make sure there's labor peace if you just agree to only use union contractors on a project. That's not a proposition that makes sense to anybody, right?
That's extortion. That's legal extortion. And by the way, on those projects, they come in because there was no competition and because there was no way once you only had a couple of companies, the change orders. Projects in Wisconsin typically came in 100% or more over budget. 100% or more. So it doesn't matter what the RFP says, and the bid was, they're 100% on average more than what that bid was. In fact, why even bother bidding at that point? Why not just assign, this is our state builder. This is our state construction company. These are the people who are going to work on the roads. These are the people who are going to do, plumbing. We'll just pick what we always pick. And let the costs, we'll say, well, what the cost, the bid's coming in at whatever, we're just going to double that. And that's what we're going to make our expected cost. I don't know if the state of Wisconsin would be comfortable, but that would be more honest if they get rid of PLAs.
Yeah.
Or the PLA law, rather.
Yeah. In a past life, I was working with a contractor, a subcontractor on a job with the general, and I'll never forget the visits to the trailer, the general contractor's trailer about change orders. I mean, you're exactly right, Vicki. Exactly right about that. And the taxpayers of Wisconsin, they ought to be paying attention to this, because the only thing that happens if they go back in and restore the power that WEAC and the government unions had in Wisconsin prior to Scott Walker's Act 10 reform, if they go ahead and go back to this limited competition contracting process for government work, the only thing that's going to happen is taxpayers are going to be forced to fork over more money for probably less efficiency and really probably nothing greater, because they've given a monopoly to a private organization, i.e. a labor union.
Yep. And expect somewhere in the neighborhood of $1.5 to $2.5 billion increase in the cost of government for nothing. For nothing. You're not getting anything for it, but Act 10 has saved $1.5 to $2.5 billion per year, and not seen reduced productivity, and not, and saved money, and not had to, and actually been able to increase, other types of government services. Not that I necessarily think that was the right thing to do, but that's what they've been able to do. So just government's going to cost $1.5 billion to $2.5 billion more per year if the left have their way and take the minority opinion in any one of the multiple Act 10 cases and decide that it is going to make it a majority opinion, which is what Janet Protasiewicz will do. She's pretty much promised it.
Yeah. Elections have consequences. We know that. We're learning that in a greater scale every day, aren't we?
Every single day. Mark Mix, a pleasure. Thank you very much for joining me today.
Thanks, Vicki.